Hi, folks. Welcome to this live recording on Substack and on YouTube. And I'm here with Ryan Goodman, and I want to give you a quick overview of what we're going to talk about in the next hour. And we're also going to take questions, but I want to get right to it. There was a Supreme Court decision yesterday. We're going to talk about that import, and it came on the heels of a Supreme Court argument in the Birthright citizenship case. We're going to briefly talk about that as well. And I'm particularly interested in talking to you about some comments made by various of the justices and what it sort of signals to me. And Ryan's going to give his take as well. But we're going to cover that. And then we're going to cover the sort of the critical question that, I know Ryan gets, I get. It may now be the number one question I get, which is what exactly can the courts do when the executive branch is defying a court order? We've already seen some of that start, and we're going to talk about some ideas that have been reported and our take on those ideas. So those are the sort of three main things, and we'll take some questions, but let's get right to it. Ryan, good morning. It is
Good
Saturday
morning.
morning here in New York. So should we just get right started and talk about the decision yesterday? And I think the name of the case, by the way, which is always confuses me because it's AARP, which when you're my age carries a very different connotation than what the case is. This has nothing to do with the AARP that has inundated my mailbox as I approached the AARP age. Instead, it's because the immigrants who are bringing this suit, the people who are part of the named plaintiffs, and then the class that the named people are going by initials to protect them from a whole variety of things. And they've gotten court permission to do that. And that's why you see cases called AARP or JGG and initials like that, as opposed to their full names. But that's with court approval. But anyway, Ryan, what did the court do yesterday, and what was the vote count?
Great. Two. Can I start with two corrections?
Yeah, I love it.
Two or amendments. One. Good afternoon. We just turned over to noon,
Okay, that's a
and
great
yeah,
correction. It's
there we
nice.
go.
It's nice to know that NYU professors are super granular, but that's great.
um,
It is
yeah.
afternoon.
Just in case anybody didn't think it's actually live. And then the second is it's just an amendment, or it's kind of interesting. The Supreme Court still calls the case AARP, but the organization AARP for retired persons requested the change in the name. So in the lower courts, it's actually called something different now. They're using a different abbreviation, which is kind of funny.
Okay, well, thank you so
Yeah,
much for that amendment. Now let's turn to substance. By
substance,
the way,
right?
by the way, Ryan and I co-teach national security law, and this, if you want to get a sense of what our students have to put up with in the banter back and forth between the two of us, that's like a little snapshot, and it
It's like
helps that.
80% of the course, right?
Yeah, exactly. It helps that we like each other, or at least we seem to. So far, we do. Okay,
Yeah.
let's turn to
Okay.
substance.
so, so it's a major decision by the U.S. Supreme Court on the issue of what procedural rights are individuals due if the government tries to deport them out of the United States to another country. And the decision is a it's hard to know. There are only two dissents. That's one thing that could be said. It's not necessarily the case that it's 7-2. I think there's a strong presumption it's 7-2. Um, but it's per curiam, so there's no authorship or particular names that are given to the majority opinion. But it seems to at least include, obviously, Brett Kavanaugh because he writes a concurring opinion. It's a,
So it's
I
at
think that,
least five. I mean,
yeah,
it's sort of presumably seven, but it's at least five, or else they wouldn't have the majority to write the per curiam.
yeah. And the way in which I think about the case is just to dial back the chronology and talk about some particularly important milestones. And in a sense, I think this will dovetail with our other topic, which is defiance of court orders. Um, the way in which I think of it is April 7th and then April 18th. are the major uh, points in the chronology. April 7th, the US Supreme Court rules 9-0 that under the Alien Enemies Act, deportations, that everybody must receive notice, um, meaning that they're told that they're being deported under the Alien Enemies Act, and the ability to effectively use their habeas rights, which means to get to a court to contest the use of this governmental power. And they could contest it in multiple ways, potentially. That's still to be determined what exactly, but at a minimum, they could contest it on the grounds that they're uh, incorrectly identified as members of the Tren de Aragua Venezuelan gang that's subject to the
TDA.
alien enemy, yeah, TDA,
TDA.
subject to the proclamation. That's April 7th, a resounding call out to all of the circuits, all of the judges, and especially the executive branch that these people need to be given notice and an opportunity to get to a court to effectively exercise their right to a habeas. 9-0.
And one of the things about the decision yesterday is it also wasn't 100% clear that it was 9-0. There just was no dissent, and so you didn't know whether all nine actually agreed or whether it was five and the other four may have quibbles, but they didn't really vote for it. But the decision yesterday actually says that it was 9-0. And so you have confirmation from the Supreme Court itself, which is, remarkable. I mean, it was something I think everyone intuited, everyone sort of thought had to be the case. And it also is such a core obvious point that before you have this kind of deprivation where, and I, by the way, don't like to use the term deported because it suggests a legal process was in place. This actually was, to use sort of Judge Wilkinson's terms from the Fourth Circuit, he basically says these people have been snatched and stashed in a foreign prison, to sort of suggest that this is not sort of going through normal court processes, and that's the problem. And so you have the court yesterday making it absolutely clear and reaffirming this idea that it was 9-0 for a due process right, to be heard with respect to, and just to be clear, two issues. The legality of using the Alien Enemies Act. Does it even apply here? And Ryan, as you said, even if the court were to say the Alien Enemies Act does apply, are you in particular subject to it? Are you part of that gang? Or are you a mistake, such that you shouldn't be deported, or extracted based on that law, even if that law is validly exercised in general to people who are part of the group? You get to say, I'm not part of that group, and they haven't proved it.
Yeah, and I'd even throw another one in there. You could also say, I am subject to a separate judicial order that prevents me from being sent to El Salvador or
Yeah.
from being sent out of the country. There's a case,
Abrego Garcia. Abrego
Abrego
Garcia's.
Garcia.
Yeah.
Yeah, and there's another one, JOP, which is even more squarely on the same
Yep.
on all four, in the sense that individual in JOP is under the Alien Enemies Act, and he is a Venezuelan national identified by the government as supposedly Tren de Aragua, and he was precluded from being sent out of the country under a settlement agreement that was judicially enforced. And the judge there, a Trump appointee, has found that the government sent him in violation of law, never gave him the opportunity under habeas to contest that. So that all of these reasons why you want people to have the chance to argue that they shouldn't be sent to El Salvador, out of the country.
And for our listeners, that's Judge Susan Gallagher, who's
Yep.
the Trump appointee, who joins many, many, many judges across the sort of political spectrum, ruling against the administration. Okay, so that you were talking about April 7th is one of the dates. What's the next date for you that you're sort of focused on?
So the next date I'm focused on is April 18th. That's actually Easter Friday, easy way to remember it. And in fact that it's Easter Friday is actually relevant to the set of facts. Um, One other aspect I think it's good for people to know about the Supreme Court, because you have to try to understand where is the Supreme Court going on all of this and how supportive or not are they with respect to the Trump administration. The 9-0 on April 7th isn't a 100% defeat for the Trump administration. The court also says, look, these cases have to be brought in habeas, which means instead of what would have otherwise happened and what the ACLU wanted, which is one case in DC and class wide relief, the court says, no, it has to be brought in habeas in the individual jurisdictions or districts where people are held in custody. So that's April 7th. And then April 18th, Easter Friday, lo and behold, in Northern District of Texas, the ACLU gets wind of that some of its clients and others are being brought to the Northern District of Texas from around the country in order to put them on planes to bring them, fly them to the CCOT prison in El Salvador. And so they rush to court because these people have not been given notice and an opportunity to bring their habeas cases. And so they rush to court to say these people are being denied their due process in Northern District of Texas. And NBC News reports not contemporaneously within the next 12, 24 hours that in fact people were on buses going to the airport. And the judge in the Northern District of Texas, Judge James Hendricks, does the following: nothing, nothing. He sits on his hands. And the ACLU is like thinking, oh my goodness gracious, these people are in imminent peril. And he still does nothing. And the
And just
ACLU,
that,
yeah,
can I just interrupt for a second? The backdrop of this, of the do nothing, is the Abrego Garcia case. In other words, the issue is that you, you have a record of what I'll call supreme defiance of the courts that is so unusual for the Department of Justice to be undertaking. In the Abrego Garcia case, there was a court order that actually said you cannot be removed, Mr. Abrego Garcia, to El Salvador. And in fact, he was. And then, as everyone I think who's listening knows, the government says, we wash our hands of it. There's nothing we can do. And so the idea of, I mean, it's like death penalty litigation, and that once the flight takes off, you're done. And then the second backdrop to all of this that would cause the ACLU and I think the Supreme Court to be very wary about the government's representations is that Judge Boasberg, sort of in the very case that led to the Supreme Court decision about due process, had said planes should not take off, and if they have taken off, turn them around. And that is something where he has found preliminarily that there was contempt of his order. And so if you put those two things together, that's the backdrop for why the ACLU would be saying now that it has to play whack-a-mole, and because habeas means that there are all these cases around the country, and they have to keep on considering now not just one case, but like where are all the people? Where are they? What are the judges doing around the country? The concern is if the judge is not ruling, that the government will just get these people out of the country as fast as possible and then say there's nothing we can do about it.
yep. Um, and so Judge Hendricks is silent, and the ACLU then makes a strategic decision that they're going to go to the Fifth Circuit Court of Appeals. And interestingly, they also try to go to Judge Boasberg again in DC um, under a technical argument that the right to notice is different from habeas, so that he could still issue an order there. Um, and they go to the Fifth Circuit to basically say that the Judge Hendricks's decision not to act is an action on his part. And the Fifth Circuit essentially says, well, Judge Hendricks says, then he suddenly issues his ruling. And he says, oh, I was about to do it. I was just thinking about it. It's kind of a wild ruling. I think it's about 6 pages where he keeps repeating that he's, short on staff because it was Easter Friday and he was going to get to it. And that they only gave him, according to him, 42 minutes. And now that they've appealed it to the Fifth Circuit, the ACLU, he no longer has jurisdiction over it. And then the Fifth Circuit um, is, we're waiting to hear from them. That's when the Supreme Court, right after midnight, because the Fifth Circuit doesn't rule, or as far as they know, has not yet ruled. They say, okay, we're going to put a stop to this. We're at least putting in a temporary stop. And then yesterday, that temporary stop turned into a full stop. Um,
Right. So until yesterday, the Supreme Court had said everything's on hold. And so, at least with respect to everybody who's in the putative class, which is dealing with a part of Texas, there's, because of this habeas issue, there's not a nationwide injunction, but at least with respect to all of the people in that particular locality who would be in the class that the plaintiffs seek to certify, nothing could happen to them unless of course the government just is going to violate the court order issued by the Supreme Court. And one of the things just about this is all background, but in terms of the Supreme Court's that initial stay, it was actually, I think it was about 1252. So, and the reason it wasn't quite at 1201. And the reason there was this incredibly dramatic moment, which I think, Ryan, you and I have talked about, um, is that before Judge Boasberg, and I think to the government's credit, at least, they do say to the judge, we are not doing anything now today. And we assure you that we're not doing anything today, but I have to advise you that our view is that we have the prerogative to do whatever we need to do tomorrow, which would mean 1201, because that would be the
yeah.
next day, in the same way that you corrected me so wisely to say we're in the afternoon.
Right.
And so that meant at 1201, there was actually about a 52-minute period where, everyone probably was on tenterhooks as to, is the Supreme Court going to rule? So
Yeah.
that led to this ruling that was issued yesterday, the per curiam, where you have two dissents, Justice Alito with Justice Thomas, and you have a concurrence by Justice Kavanaugh with the per curiam. But why don't we just focus on the per curiam? What did they hold? Because it was there's this phrase. It seemed pretty close to a bench slap, because it was pretty. I thought if I were the district judge, like, I'm not sure I'd want to get up that morning, because
Yes.
it was pretty scathing.
Yes. So I think that's a good place to start. It's a very strong rebuke of Judge Hendricks in the Northern District of Texas, and a rebuke of the Fifth Circuit.
Right.
To the Fifth Circuit, they say, "Look, you could easily have exercised jurisdiction given the nature of the case and how the imminent threat of grave harm to these individuals." So the Fifth Circuit, you could have exercised jurisdiction. To Judge Hendricks, I think they're just shocked by him. And they also correct the record that it was not as he claimed that he only had these 42
Yes.
minutes to decide. They say it was actually 14 hours, and they have exactly how many minutes after the 14 hours, but it was north of 14 hours, and he still had done nothing. And in the situation in which these individuals' lives were at such great risk, and the affidavits that the ACLU submitted alongside their petition to him, that he should have frozen the status quo. So it's a very stinging rebuke of him, and especially if anybody wants to go back and read his 6-page uh, excuse, I recommend doing it just to get a sense of what happened there. But that's to the side in terms of the bench slap, and then the fundamental question about how we understand our Constitution.
Right.
The Supreme Court says nobody should be removed from this country without a hearing, which is also, I thought, quite the contrast from Kristi Noem saying, the Secretary Noem saying in a congressional hearing just 24 hours, I think it is, beforehand, that there's due process doesn't require a hearing, like, which is just quite
And
sickening if you think
Steve,
about what that means for these people.
Stephen Miller has tweeted the same thing, that due process does not apply to immigrants who are being removed from the country. It only applies to, in criminal cases, to criminal defendants. Presumably, there would be just citizen defendants. I mean, a very crabbed reading, but it's not really just even a crabbed reading. It is a reading that is directly contrary to the Supreme Court's first decision, and now its second decision, yesterday, reaffirming this and saying it's 9-0. Even the dissents, it's worth noting that the
Mm,
dissents are not on that issue. They're not
right.
saying that we don't think there's due process. It is on a procedural issue about whether they should have taken the case, whether there should be class certification. I mean, all sorts of procedural issues. You still have, I mean, it's worth really reemphasizing that it's 9-0. Nothing changed in the course of the month, where the court is not
Right.
changing its view. It remains to be seen as to what exactly the notice has to be, what the amount of time, what the hearing has to look like. And the court actually says that. They say, whatever that is, this ain't it.
Right.
like, you know,
Right.
and when we're sending it back to the Fifth Circuit to evaluate various issues. There's the issue of whether the statute is even properly invoked. There's issues about what the notice would have to be, what the hearing would have to be, and it sends it back to the Fifth Circuit to look at that issue, and for the district court to look at it in the first instance. But there's a stay in place. In other words, it's not like they can go ahead and remove, and the court's very, very careful with its order to make it clear that it's going to stay in place, to make sure that they're not playing this game again of needing to of sort of death penalty litigation where the plaintiffs have to rush to the Supreme Court again
Right.
to get a stay. The other thing, Ryan, I thought was significant was the issue of how they dealt with class certification.
Can I just jump in one point before that?
Yeah, yeah.
Just on the due process point, I do also think there was something potentially revealing and significant in the Supreme Court's opinion, in the sense that they didn't just say that you have to give people more than 24-hour notice. But the one thing that I've been focused on is notice of what? Because in lower courts, the government seems to be saying that they could have given just 12 or 24 hours notice that the person was going to be removed under the Alien Enemies Act, but not notice or information that the individual has the right to contest it and right to a habeas hearing. And in the Supreme Court opinion, there's this one line that I thought was quite interesting. They say, under these circumstances, notice roughly 24 hours before removal, devoid of information about how to exercise due process rights to contest that removal, surely does not pass muster. And it's that second part, devoid of information about how to exercise due process rights. So that has to be a component of the Fifth Amendment right that they're talking about. I think that's good of the court to already signal that that's where that's going to go.
Yeah, and I think part of that is that the government has lost so much credibility with the court in terms of the gamesmanship that's why we gave a sort of long preview of and a ramp up to how we got there,
Yeah.
and the affidavits that were submitted by the ACLU, suggesting that at least some of the people at issue were basically just told you're being removed, but nothing is being said about. It's like the president, they were just told the president's doing this, as if it's like, okay, now you're on notice, but you don't know that you can even contest it. And they're
Thousand
being
percent.
told
Yeah.
they're just being told, like, and don't you, it's like the president's doing this, don't you consent? Is what
Totally.
was sort of the
Yeah.
language. And so that's the kind of thing, I teach Fourth Amendment law. That is like so not what you can do. It's not like my analogy in the Fourth Amendment context, sorry to belabor this, but it's like you can't just say, by the way, I have a search warrant for your home, so don't you consent anyway? But it turns out you don't have a search warrant. So
Right.
here saying, well, the president's removing you, it's like, no, 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 no. That's the kind of thing where the president's maybe seeking to remove you, but you have a right to be heard on a whole variety of issues. And I have to say, this is where, even with the dissents on the separate issue, they're very much, really feels like a rule of law decision. And it's gratifying to see it in a 9-0 context. And they should say even the Kavanaugh concurrence is really about speed and timing. It is not disagreeing with the substance of the per curiam majority view.
Yes. Yes, and so
So
let's
let's
turn
just talk
to
about
let
class
class
action part.
yeah,
Yeah.
exactly, and I can set you up with it in this way. There's a so for you to talk about what's interesting in the court opinion about class certification. But one way to set it up is to let people know that in the last several days, it's in the last week, I think, or so, but I think it's in the last week, Judge Hendricks issued another order that's quite unusual. He became the first judge in any district not to accept individuals in his district who are being subject to the Alien Enemies Act as a class. He actually denies them class certification, saying things like that they're too different in character to be one group. And so that's already in the docket below. And then the Supreme Court does something quite unusual. Do you want to?
Yeah. So, I mean, here, I want to make sure people understand because it's going to relate to birthright citizenship, that the argument from 2 days ago, which is procedure and substance matter. We talked about how these cases have to now be brought by habeas, so they're brought all around the country, not in one court. It makes it much, much harder for people to vindicate their rights. It's why you see the ACLU running around the nation trying to prevent the deportations without due process. And one of the ways that you can mitigate that is when you have a class action. Now, in this habeas context, it's not a nationwide class action, but this is all very technical, but it's a class within the particular jurisdiction of the court. And so you may have many, many class actions, but that's preferable to every single individual having to bring their own individual case. I mean, that assures that rights will be violated because it's just almost impossible to think that the courts will be able to handle, let alone that there'll be lawyers available to
Right.
that many people. And it's much, much harder to vindicate your rights. And so here, the proposed class from the ACLU was in this Northern District of Texas, and that was the putative class. And so that would cover a wide group. Again, not what they had ideally wanted when they were before Judge Boasberg, but complying with Supreme Court rule, which, by the way, was 5-4. Amy Coney Barrett was not in the majority on this. It was not 6-3. It was 5-4 on this habeas issue, if I think I'm right,
Yeah.
Ryan.
Yes.
And so again, Amy Coney Barrett has proved really interesting to watch in on the Supreme Court. And so the court basically says, you know what, this is appropriate for a class. And they reach into the case. And it's sort of unusual because that's not sort of directly, it wasn't sort of directly presented. And I think this was basically like we've had it with the gamesmanship. Um,
Yes.
and I also feel like they were so appalled. I mean, this is my speculation, so appalled by what Judge Hendricks did, both procedurally in terms of sitting on this and then substantively. And just on the merits of it, a class action is not precluded just because there may at some point be individual determinations if there are overriding commonality to the legal issues. And here, the key one is common to everyone, which is does the Alien Enemies Act even apply here? Is there an invasion by the TDA on behalf of a foreign government? That is the same for every single person in the putative class, frankly, not just in the Northern District of Texas, but for everyone as to whom across the country, as to whom this could apply. And so there's no reason not to have that issue decided on a class-wide basis. And then everyone in that putative class gets to enjoy that. And they get to enforce it. They get to say, that is a ruling that applies to me. It's not
Hmm.
just precedent. It's something that is giving them a right that they can enforce. And I think given the gamesmanship, I think that was my read as to why the court sort of reached into this to say, we're not having this come back and forth on this and have to play whack-a-mole, or to quote Ketanji Brown Jackson from the Birthright Citizenship, she didn't use the phrase whack-a-mole. She said this is the government sort of playing a catch me if you can
Right.
game. And this helped not prevent it, but thwart it.
Yes. Yes. And Should we segue into the birthright citizenship and how this connects into it?
Yeah.
Yeah.
So just so everyone is aware, 2 days ago, the court heard argument on the birthright citizenship case. I think as for people who are following this, they're aware that the merits of what the government was seeking was not before the court. In fact, one of the oddities is that the government isn't presenting to the court the constitutionality of its view that birthright citizenship doesn't apply to people who are undocumented or even people who are here legally under, let's say, a student visa who then have a child. And so they're trying to, for the first time, say that this constitutional provision does not apply. As Justice Sotomayor noted, that from her point of view, this violates 4 separate Supreme Court decisions. But that wasn't before the court. What was before the court was this idea of nationwide injunctions and whether every single court that has heard the merits of this has struck down the actions of the government trying to change birthright citizenship and issued these injunctions saying, do not do this anywhere, precisely because you don't want a patchwork and a sort of crazy quilt of rulings where if you're in Louisiana and you're here on a student visa, your child is suddenly not a citizen. But if you're in Massachusetts, they are. And I'm just picking sort of random places. And so you'd have all these crazy rules. And as well, as my colleague Mary McCord has pointed out, it would affect all of us because normally to prove citizenship, you just show your birth certificate. But this would mean that in various places around the country, that wouldn't be sufficient because the fact that you were born here would, in some locations, mean one thing and in other locations mean another, causing just no end of chaos and, to my mind, no end of cruelty in terms of this. So this is another example, by the way, of procedure and substance relating to each other, that nationwide injunctions are a way of making sure that if you start with a hypothetical that the actions of the government are unconstitutional, there's no gap in time before this. If you basically said, oh, there's no nationwide injunctions, but only the Supreme Court can give a ruling that sort of applies to everybody. By the way, why the Supreme Court should have that power, but not any individual federal court remained a sort of mystery to me. But that gap in time means that there will be people whose rights are violated during that period unless they can sort of somehow get to every single court and have lawyers and have injunctions, very much like what we were just talking about in the habeas context with the Alien Enemies Act, is now replicating itself in terms of procedure having a real effect on the substantive rights.
Yeah. And I like the way in which you describe it, that especially if you work with the hypothetical, and as Justice Kagan mentioned, like this is not hypothetical in the birthright citizenship case,
Right.
you're clearly wrong. Like you have a loser of a claim of a case, and you're losing across the board. But then we have to analyze it in that situation, and I think that's a way of also segueing to what was the most startling point of the oral argument, which is that we can give another kind of a hypothetical. Well, what when a court of appeals rules in its opinion that X is completely unconstitutional, on its face, can never be implemented, and X being some executive action or an executive order on its face, surely at least that would then govern the law within the Second Circuit. Let's say if it's the Second Circuit that does that. And that was the startling moment that I think many viewers will be attuned to, where the US Solicitor General says to Justice Kagan and then to Justice Amy Coney Barrett, who follows up on it, as the two of them often do in oral argument, um, oh, we don't commit to always abiding by the Second Circuit's opinion. We will commit to abiding by the particular judgment with respect to the particular plaintiff that has brought that case, but we might still continue marching on and with the executive order that the Second Circuit has deemed to be unconstitutional within the Second Circuit, meaning like state of New York. All other residents, they'll still apply what is deemed to be unconstitutional for that circuit. And I think that's just an astonishing moment. And in fact, Justice Amy Coney Barrett is not picked up in the
She
transcript. You have
agrees
to,
with you.
yeah, it's not. It's funny if you look at some transcripts. Then AI misses where she says, because she says it in the middle of the U.S. Solicitor General speaking. She says, "Really? Like, no, you're not saying that, right? Really? I can't believe you're saying that." And I think that's another part of the issue where the Justice Department and this administration is losing credibility before the Supreme Court. The Supreme Court's not trusting them at a
Yeah.
certain
So
point because
so
it's just too
Ryan,
many times. Yeah.
Ryan, I was in the Justice Department for 21 years, under obviously under various administrations, Republican and Democratic. The idea that there are actual contempt proceedings now as to the department,
Yes.
and that the department wouldn't say, Judge, if you issue an order, we're going to follow it. We may ask for re-argument, we may appeal it, but we're not going to play games. We're not going to be trying to skirt it. Your job is not a hockey goalie.
Yeah.
And if we have any concern that we think it's unclear what your order is, or we think we can do X but not Y, we're going to come back to you to make sure that we're not we're abiding by your ruling. I mean, it's just you're part of the Department of Justice. The idea that you could, I mean, the normalization before the Supreme Court of this kind of behavior is sort of remarkable. And I actually wanted to talk. That sort of is a good segue to. I'm going to be pretty scathing with respect to Justice Kavanaugh and Justice Alito in the oral argument. I don't know where they're going to come out, although I have a pretty good idea from their questions. But Justice Kavanaugh went out of his way to say, oh, essentially, why can't we just all get along? And, White Houses want to act quickly. And so all presidents want to act quickly. And here we have a president who wants to act quickly. And we've had prior presidents who want to act quickly. As if it's like, oh, this is all normal. All people like to breathe. And taking the most anodyne thing, which is that the people like to act quickly, as if there's no substance difference.
Yeah.
It's not like any president previously has challenged the idea of birthright citizenship, or thought that there shouldn't be due process, or had senior officials who are senior advisors or cabinet members saying due process doesn't apply when the
Right.
court has just said that. And so he at one point said to one of the litigants, he said, so, we can all agree that there's good faith here. Excuse me? I mean, it was remarkable first of all, what is the litigant supposed to say? Like, I'm sorry, you want me to vouch for the good faith of the people in the White House? I mean, I would be really tempted to say, you know what, let me just bring some reality to this courtroom. Good faith, there is a contempt finding by Judge Boasberg. There are contempt proceedings before that Judge Zinnes is doing in the Abrego Garcia case. There is a person sitting in jail, Abrego Garcia, and many, many others whose due process rights were violated, and this administration is not doing anything about that. And you think there's good faith? I mean, it was so remarkable. And the idea, I think, because of the trappings of the Supreme Court, and if you're in the building, it's sort of this very august thing. I think some of the best advocates I've seen know when to bring reality to the court. I can't say shocked, but it was remarkable to me how much that was trying to normalize, in my view, what is going on. And then Justice Alito, just very quickly, basically said, hey, the reason we don't want nationwide injunctions is because these district judges are just out of control, and even the courts of appeals are out of control. So we really have to take control, and we don't want to let them do this. That was the same dismissiveness of structures and procedure that you saw in the presidential immunity case, where he said you can't trust the Department of Justice, you can't trust grand juries, you can't trust trial judges, you can't trust trial juries, and you can't even trust the criminal law with and the burden of proof being beyond a reasonable doubt and the need for intent. That's why we need to have immunity, because there's nothing else that will protect someone from, even with all of those things. And so you had a Supreme Court justice is saying about his colleagues, oh, they're all out of control, and essentially only I know what's right. I mean, it was remarkable to me, the disdain he had for the judicial system.
Yep. 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 And I think with that, let's segue to what is going on across the country, which is in Judge Boasberg's courtroom, the finding of criminal contempt. That he's already had a finding of criminal contempt on the part of the administration for the failure to abide by his initial orders of returning the flights. And I see that's some of the questions that people are asking in the chat. The Abrego Garcia case is another instance where Andrew just mentioned that Judge Sines is engaging in another contempt proceedings to determine whether or not the government acted in bad faith versus good faith. And in fact, you can tell from yesterday's hearing, she's, I think, going straight towards this is bad faith, in the sense that they have done nothing to take steps to facilitate the release of Abrego Garcia, which for Justice Kavanaugh, you would think that's not just a violation of her orders, it's a violation of the Supreme Court's order in
Right.
that regard. And that they've also engaged in other forms of contempt, because she said, look, following the Supreme Court, which said that you are supposed to keep me updated on what steps you're taking, I ordered you, government, to give me information from people in the administration who have personal knowledge of steps that have been taken, and they've refused to do that. They've given people who are much lower down the chain, who can only speak based on like hearsay and things like that. And apparently in the record are saying multiple times, sealed record, I don't know, I don't know, I don't know. And she wants to, and she's also saying you're not doing that in good faith either. So that's happening there. There are other cases. People are aware of the uh, Consumer Finance Protection Bureau. In that case, there was an action by the government to basically dismantle the bureau, even after there was an order from the district court to
Right.
maintain staffing. So it's across the board. And then what people
Right.
are also asking in the chat is, and this is where we want to talk about this, what are the powers of the courts? Can they
Right.
take people's licenses away or things like that? And the reason that Andrew and I thought about talking about this today is because you have to anticipate it in advance. And we have to imagine that these various federal judges are thinking right now, what is the end game scenario?
Right.
And then everything they do now must be in anticipation of that end game scenario. And in my mind, there are multiple tools they have to address contempt and civil contempt and criminal contempt on the part of the officials. So they should not look for off ramps. They should confront the contempt if the contempt is happening. If there's an off ramp because the contempt's not happening, that's great.
Yeah.
But
That's not an off ramp.
yeah,
That's just applying the
yeah,
law.
yeah,
I totally agree with you. And I also think one of the things that I learned from working on the Mueller investigation is, at the moment you start applying different norms, it's like you are really undermining the rule of law. It's like treat everybody the same, apply the rule of law as the facts warrant it. You can't pull your punches, or you really are in fact violating the rule of law, and you're and it's sort of a never-ending cycle, and it circling the drain. Quickly, civil contempt is the power of the court to coerce the person in front of them to get them to comply with the court order. Criminal contempt can be for the same action, the same violation, but it is imposing a punishment for doing that. So they're very separate sort of things. But I'm going to just throw out one of the things that the court can do, because this is sort of the issue is, as Ketanji Brown Jackson said, this is not just, she was talking about catch me if you can. This is really, if the court is dealing with the government saying, stop me if you can, meaning I'm just going to continue doing this. And how are you going to stop me? Because, of course, courts do not have armies. So one thing they can do is they can order the marshals to do things. They can order the marshals to bring someone to court. They can order the marshals to, if there's a fine imposed, to actually seize assets or to put a notice of a freeze on a bank account. And the marshals can sort of manually do what the court orders. The problem is even the marshals may in fact abide by that order because the marshals have taken an oath to uphold the law and the Constitution. But the marshals are a part of the executive branch that is part of the under the control of the Attorney General and the White House. And so even if you have a marshal who says, well, I'm going to comply with the court order, they can be told by the White House not to, and they could be fired. And so if they say, well, I'm not going to do that, we've seen Department of Justice attorneys be fired. And so the executive branch has a way to deal with the marshal who says, I'm going to comply with the court order. And of course, there are marshals who may, I don't know, this is speculation, but some marshals may be like, I'm not going to comply with the court order if I'm ordered by the executive not to. But in any event, the executive has this ability to sort of have the marshal stand down by telling them not to or even firing them. So the marshals are not a perfect solution if those things happen. And so the issue is, what else can the courts do if the marshals are not allowed to, are willing to carry out the court's order, but are not allowed to by the executive? So what are some of the other ideas that you have and that other people have written about?
Great. Yeah. So we published a piece in the last 2 days at Just Security, which goes through a menu of options that courts have in the event of contempt on the part of the executive, and in a scenario in which the U.S. Marshals do not abide by their statutory obligation to effectuate court orders. And I think of them some of them as like self-help mechanisms, but one is a line of Supreme Court cases. There's a very important case in 1987, Young v. Vuitton, in which Vuitton, the Supreme Court basically says that federal courts have inherent authority to appoint their own special prosecutors and things like that, so they could appoint their own officials who can carry out their authority, when we're talking about a case of contempt. And the court's opinion, 1987, is about the fact that the third branch of government should not have to rely on the executive branch. Um, so it's a prescient case for what we're thinking about today. And that's the basis on which a judge could do so. And it sounds as though Judge Boasberg is maybe already thinking that. He references the fact that he could appoint a special prosecutor if he makes the determination that that's where he wants to go on the criminal contempt
Yeah.
issue.
And
So that's one
there
avenue.
have been, it's very rare, but there have been cases where judges have done that. I mean, fortunately, it is very rare. Normally what happens is the Attorney General is given the first option to prosecute the matter, but if the Attorney General says no, they're not prosecuting it, then a federal judge can appoint someone. However, that person ultimately is reporting to the Attorney General. There is a wrinkle there. And so whether that gets sort of ironed out, where in a situation where there is this independent appointment by the court to vindicate the court's own authority, whether the Supreme Court will say, no, we will not allow the Attorney General to then fire the person or tell them not to prosecute.
Mhm.
Like that's sort of, I would say, is somewhat untested territory. But that it certainly puts the administration behind the eight ball and makes them really have to confront and the public see what they're doing. And
Yes.
so what I would say is there may be political costs, and it's not totally clear to me that this Supreme Court won't say, as part of our inherent authority to enforce our own orders, we have to have a mechanism outside of the executive and the legislative branch, or else there is no check and balance. That it can't just be our orders are just wishes on our part. There has to be something that does it. So one is this idea of a special prosecutor being appointed.
Yeah.
Another is there real consequences to the lawyers who show up.
Oh,
Um,
can I just drop a footnote on that one?
yeah, yeah,
Just to
yeah.
make people alert. Yeah, that this gets a little bit into the further into the legal weeds, but it's just good to alert people that in 2023 there was a U.S. Supreme Court case that was going to go to the court. The court decided not to take it, and it's very similar on the appointment of a special prosecutor by the judge themselves. It's Dunziger versus United States, Donziger. What's remarkable about the case in 2023 is that Justices Gorsuch and Kavanaugh seem to say, look, this is not a power necessarily of the third branch. This really is a Article 2 power of the executive branch. And they cast doubt on this 1987 precedent. They also somewhat
But it was
distinguish
interesting
it.
to me.
Yeah,
But it's also that's just two justices, and
yeah,
this would come up in the context that is. And it'd be very interesting to see whether, yes, it is possible that they would overrule that old precedent. Obviously, from the presidential immunity decision, we know that there are at least five justices who think of the sort of executive power and the prosecutorial power as being something that is exclusively and preclusively within the president's purview. This could be distinguished, though, because it's a very small subset of enforcement of the court's own orders and appointing a prosecutor in that limited context. It is not saying, oh, you don't want to prosecute somebody for securities fraud, so now the judge is going to appoint someone for it because you think that's an important thing to do. This is really about enforcement
yes.
of the court's own orders.
Yes, and from the cases we're talking about, it's also the enforcement of the Supreme Court's own orders. And I do think, just to say something that cuts across all of these mechanisms for courts to enforce their orders in the face of contempt, something that addresses an issue that's popping up a lot in the chat from viewers is like, what can Americans themselves do? What can the public do? I just want to say that, as Andrew described it, like, this kind of case is different from the one that Justice Gorsuch and Kavanaugh spoke about. I also think at the background for all of the courts, all of the judges, they are human beings that care about their institutions, and in many instances, I think, care about the legitimacy of the institutions. And public sentiment is really important for that. So I do think one of the things in terms of what can the public do is be outraged if there's outrageous conduct, and speak to your representatives. These town halls where people are showing up and saying, "What are you doing about this? This is about democracy and the rule of law. What are you in Congress doing? Or do you have a censure resolution against the secretary of some agency for not complying with court orders? What are you doing to enforce them?" But just creating the idea that this is unacceptable in the United States. And I think that is kind of giving the courts stiffening of their spines to do the right thing and stick with how the law should be applied.
And I have said this repeatedly, which is that members of Congress and as well as like pollsters very much focus on what is the level of outrage, how the numbers and the level of concern. So even if you're in a state where you say, oh, but my senator or my member of Congress already agrees with me, the more they hear, if you think this is important to you, you should speak up. We still have a First Amendment right, and you should be noting that. One other tool that the courts have, in addition to appointing somebody, is there can be real consequences to the person who appears in front of them, and potentially to their bosses and their agency writ large. And so if somebody shows up from, let's say, the Department of Justice and just says, "Judge, I'm not following your order," they can be held in summary uh, contempt right then and there, and and actually the marshals can actually be ordered to take them right then and there to jail for if the contempt is happening in front of them, and so it could happen so quickly that there isn't the ability to countermand what the marshals are doing, at least in that immediate context. It reminds me very much of what happened with the student Ozturk, who was released and was just sort of happened very, very quickly, which was very smart on the part of the district judge. The other is there can be consequences to the bar license of that person. They can be stripped of being a member of the court. Each court approves who gets to appear in front of them. They can somebody who's been in civil or criminal contempt can be barred. They can be disbarred. There's a whole process, and there's due process for the person who engages in that. But we've seen that in connection with, let's just take one example, Rudy Giuliani, where there can be disbarment proceedings, and so there can be consequences to the individual lawyer who has to show up, and the judge can sort of keep on doing that to say, like, I want so and so to appear in front of me, I want your boss to appear in front of me, and there can be those consequences. And again, I know that's not it's not a panacea, but that is something that it certainly stiffens the spine of people who are in the Department of Justice, who are thinking, those people who may be thinking, I just want to keep my head down. Well, if the court is telling you to do something, your boss might want you to do something else, but if there's a court order, a lot of people are like, I'm not losing my bar ticket over this. And the court definitely has the power to do those kinds of referrals, and to make findings that could be extremely damaging to people's careers if they were to engage in this kind of conduct. I just want to make sure people understand that if that happens, the person involved has due process rights. I mean, they have an ability to say,
Right.
in the same we've talked about it in a much more serious consequence with respect to people being extracted from this country. All of this is something that the person who's doing this would have a right to say, I acted in good faith. I didn't think I was in contempt, and make any and all legitimate arguments.
Yeah. And the piece that we published in Just Security, the title, if people want to Google it, is When the Executive Defies the Judiciary. And I think it's important also to look back at history. It's interesting, in 1951, there is, in fact, a DC Court of Appeals decision in which had ordered that the Secretary of Commerce and other officials would be jailed for civil contempt of the court's order. It is stopped at the last minute by the Supreme Court in a stay, but it's not like the Supreme Court said you don't have the power to do that. And it's resolved with an off ramp. But that's also what that can do when you really threaten it or enact it. Um, that can bring the government back into compliance. But it's
The other is, yeah, the other is, depending on what the nature of the suit is, the judge has various things that they can do in that case. So the Rudy
yes,
Giuliani case, where he was sued by Ruby Freeman and Shay Moss, is a perfect example where Judge Beryl Howell had to deal with what she found to be repeated civil contempt by Rudy Giuliani and not turning over various documents that he was required to. And she gave him lots and lots of opportunities to comply, but ultimately made various findings that were binding on the jury, which was, that the documents that were not turned over would have been favorable to the plaintiffs. They shouldn't be harmed by that failure. And so she made various adverse rulings that were sort of related to the contempt failures. And so that's a way that the judicial rulings and the substance of the judicial rulings can be affected. So, for instance, in the Judge Zinnes case, where she's trying to decide if there's contempt and she's holding factual hearings, if there's a failure to comply, she can say, you know what? I've ordered you to talk and to give a deposition. You are not complying with my orders. She can ultimately do the sort of Beryl Howell route and say, I'm going to make adverse findings. So there are a lot of interim steps that can be done that puts more pressure on someone to actually comply. Again, that doesn't deal with the ultimate issue of what do you do when the judge says, and now do this, and they say no. But it does give a plaintiff some additional relief in terms of advancing their case, improving their case, and they're not hurt by the contempt of the, or less hurt by the contempt of the defendant.
Yeah, and I think that's another way that I think of it, and it's in some ways helped by Steve Laddick having highlighted this. The executive branch also depends on the courts. And if the courts are going to issue adverse findings against the executive because of their contempt, that might be another way in which there's a check, and that against abuse and against a contempt on the part of the Justice Department or the various departments and agencies. So those are some of the mechanisms that are available. And I do think that we're currently in this limbo state because right now the executive branch is in contempt of these court orders in different locations, and they're being resolved with Judge Boasberg uh, being able to at some point move ahead, one would think, and then Judge Sini's moving ahead, that we will see the confrontation. So I think that's what people and members of the public should be on their toes, kind of waiting for that potential collision.
Yeah. So right now we're at time, so we're going to stop. Hopefully, what we've done is given some explanation of what's happened this week, but also tools to understand this confrontation that we are going to increasingly, unfortunately, see between the executive branch and what I will say is probably the last branch standing, because we're not seeing a ton of pushback by the legislature. So these really remarkable decisions from the Supreme Court that are 9-0 on the substance are ones that we're going to see this increasing vilification by the executive of the courts, and the courts standing their ground. And the issue is, what can they do? So stay tuned for more. Ryan and I will be back to talk to you again about various things that we think are important to talk about. Thank you very much for the questions you have in the chat. And we will see you later. Stay tuned, stay engaged.